Hello and welcome. This short video aims to clarify the information about the Certificate of Training Alternative Pathway under AMDRAS. I'm Joanne Law, the Director of Mediation Institute, and this information relates to the program and processes that you can access through Mediation Institute. The standard approach to become a qualified accredited mediator in Australia is to complete the Certificate of Training and then the Certificate of Assessment. The Certificate of Training confirms that you have the foundational knowledge and skills to become a mediator. The course duration is a minimum of 45 hours and must be delivered by a recognised training provider who's been approved by the AMDRAS, Australian Mediator and Dispute Resolution Accreditation Standards Board. The learning content contains information on mediation processes, skills and ethics, a mandatory 9 simulated mediation role plays, and 3 of those role plays are as the mediator with structured feedback. You can go to mediationinstitute.edu.au and /AMDRAS Certificate of Training to find out more. However, what if you have already trained in mediation and you feel that you have the necessary skills and knowledge? For example, if you've completed the Graduate Diploma of Family Dispute Resolution, you may not need to complete the full Certificate of Training course. You can complete an alternative pathway protocol program to meet the requirements. There's an application form that you can complete to start the evaluation process if this is something that you're interested in. What you'll need to provide to have us consider your prior training for the alternative pathway is the course details, so the provider name, the course name, when you completed it, content summary, the topics covered in your course that would map to AMDRA. A general dispute resolution overview type course would certainly not qualify. Simulations, so there must have been simulations. Don't bother applying for an alternative pathway if you didn't participate in a significant number of role plays. And you also must be the mediator. We wouldn't consider it if, say, for example, multiple people did little parts of a mediation and moved in and out. As a mediator, that wouldn't qualify as a role play as a mediator for us. We also would need to know something of the trainer's qualifications. Are they just a generic trainer or are they a qualified and experienced mediator? And the timing, if your training was over 12 months old, you're likely to need to do refresher training in any case. So for an example, if you completed our Graduate Diploma of Family Dispute Resolution training, that you'd certainly have done more than 45 hours of mediation related skills and knowledge training. You may have participated in 9 facilitated mediations. You certainly will have participated in more of those overall, but we really only take into account your parenting mediation role plays. The approach that we take to property mediation is too modified to equate to the basic facilitative mediation process, but parenting is quite on par with that, to a degree at least. And you must have at least 3 role plays as a mediator. The trainer's qualifications need to be aligned with the AMDRAS standards. They are with our course, and you'd need to find out whether the trainers of your other course are actually accredited mediators, and we need to see evidence that you have had structured feedback from those role plays. And again, depending on how long ago the course was, we wouldn't just automatically accept role plays that you did 3 years ago, for example. Only courses delivered by a vocational education and training or higher education provider can be considered for Australian courses. If it's a suitable course offered by a training provider in Australia, then they have always had the option to have that recognised by the former Mediator Standards Board and now currently AMDRAS Board. So I would encourage your provider to align with the best practice in the system and have their course recognised if they believe it is meeting the requirements. So general ADR courses, alternative dispute resolution courses in arbitration or negotiation are not enough. Generally, parts of a law degree or something similar wouldn't have the level of simulations that would be required for the certificate of training alternative pathway. However, it may be that you've done a training that's exceptionally practical. In that case, you may be able to apply if it's provided by a higher ed provider. You may be asked to do some extra theory and or simulation training if your prior learning doesn't fully match the AMDRAS standards or was more than 12 months ago. So a couple of examples of what would be non-compliant. Australia mediation training not delivered by an AMDRAS recognised provider unless it's compliant education trainer. And if there's insufficient evidence provided to consider the application, for example, no information about your course content beyond the name of the course, no information about the trainers, and no evidence that you have actually facilitated simulations with structured feedback. What are the possible outcomes? One, if you're approved, you'll receive a certificate of training alternative pathway, which allows you to move on to the next step, which is the certificate of assessment. If you're partially approved, you'll receive a response indicating the gap training you'll need to complete in order to be given a certificate of training alternative pathway, and there would be fees associated with that. And if you're not approved, then you would need to complete the full certificate of training course. So in step one, complete the application form. The evidence, as I mentioned, we need evidence on the course, your role plays feedback, and so on. If you go to that address that's on the screen, you'll find the form and they indicate the information to provide in more detail. Step two, pay your recognition of prior learning fee. We'll contact you if there's any missing information. Once your submission has required information, we'll issue the application fee and the team member will undertake a detailed review and issue you with the outcome. If your application's clearly not compliant, we'll not undertake a detailed review and will not charge you the RPL fee. And you can, as I said, find out more information on the application form or the post, and links to all of these links that I've talked about in this recording are in the field below the recording. You can always get in contact with Mediation Institute if you do have any questions. Thank you.